Welcome to StudyVix YouTube channel. Always study smart and master your future. Today, we are undertaking a critical audio lecture, a really deep look into the very mechanisms that keep a company legally alive. Chapter 7 of the Companies Act, 2013.
And this isn't just theory. This is the legal foundation for every professional practicing corporate law or, accounting. We are talking about management and administration spanning sections 88 to 122. For you, preparing for the CA interlevel, this chapter is, well, it's non-negotiable because it's entirely procedural.
It's all about the how.
Exactly. It's where the failure to meet a simple 30-day deadline can trigger a really heavy penalty.
That's the crux of our mission here. Our goal today is not just to summarize the sections, but to achieve conceptual mastery, to really get why the rules exist and absolute procedural precision. We need to lock down every specific MGT form, those tricky timelines, the 30 days, the 45 days, the 60 days, and critically, the fine print of the company's management and administration rules, 2014.
Including those vital exemptions. They often come up in exams, and they can save a small company a significant administrative headache.
Right.
We're aiming to turn these complex statutory requirements into memory triggers and, actionable knowledge. Let's stop thinking of this as just a list of sections.
And start viewing it as what?
As the comprehensive compliance checklist required the moment a company incorporates.
Okay, let's unpack this dense statutory landscape, starting right at the core foundation. The mandate for maintaining statutory records. That's sections 88, 89, 91, 94, and 95. If the company is the body, these registers are its internal ledger and its memory, really.
Section 88 is the bedrock. It establishes the three primary registers every single company, without exception, must maintain. These are the mandatory records of ownership, designed to capture precisely who owns what.
So tell us, what are these three bedrock registers every company has to maintain, and what are the forms we need to know?
Okay, so we are looking at the Register of Members, which is kept in the detailed form MGT1, and that form itself is subdivided. Then you have the Register of Debenture Holders and the Register of Other Security Holders. Think of things like warrants or convertible instruments.
And those two are in a different form.
Correct. Both of those latter registers are maintained in Form MGT2.
And that distinction in MGT1 is really important, isn't it? The Register of Members isn't just one long list.
Precisely. It must be segmented. You have to keep separate sections detailing the holders of equity shares versus preference shares. On top of that, if you have non-resident owners, you must distinguish between members residing in India and those residing outside.
Which brings us to an administrative burden, or maybe a necessity, indexing.
It's a necessity. If your total membership exceeds 50, you have to maintain a separate index of the names. Without it, finding a specific member in a register of hundreds or thousands would be practically impossible. It would violate the spirit of accessibility.
Let's discuss a specialized area where the global nature of business comes into play. I'm talking about the Foreign Register under Section 88.4. What exactly is this, and why would a company even need one?
A foreign register is it's essentially a duplicate, specialized register that's maintained outside India. Typically, it's in a country where the company has a large number of shareholders or debenture holders who reside there.
So it's for administrative convenience.
Surely. Yeah. It's for those non-resident holders. But, and this is a key point, a company can't just decide to open one. Its articles of association must explicitly authorize it.
And here is the make-or-break moment for compliance, a timeline that is so often tested in exams. Let's take an example. Golden Shoes Limited decides to set up a foreign register in London. What's their critical compliance step?
The crucial step is notifying the Registrar of Companies, the ROC, back in India. Notice of the situation of the office where that foreign register is kept must be filed with the ROC within 30 days of the date of opening that register.
List 30 days.
30 days. Failure to meet that deadline renders the company and its officers liable for the statutory penalties. It's a hard stop.
We also need to talk about the dynamic nature of these records. They aren't static lists, are they? They have to reflect changes, and they must be verified.
Absolutely. The entries have to be authenticated, usually by the company secretary or a director who's been authorized by the board, and the updates are continuous.
What kind of updates are we talking about?
Any change, a transfer, a death, an insolvency, or even a transfer of unpaid dividends or unclaimed shares to the IEPF, the Investor Education and Protection Fund, all of it must be recorded.
And what if a court gets involved?
If a court or tribunal orders a rectification of the register, that order's reference must also be explicitly indicated, as per Rule 5.5. It ensures the record's legal integrity.
Okay, now for a classic legal scenario. Let's use the Luxy hairstyles illustration. Shares were allotted to Mila, who is a minor, just 4 years old. How must the company record this ownership in MGT1, given that a minor is legally incompetent to contract?
This is a perfect example of statutory requirements overriding simple beneficial ownership. Since Mila can't legally enter a contract, she can't be the sole registered owner.
So what does the director, Mr. Joe, have to do?
He has to ensure that the details of the guardian Zoe, in this instance, are recorded explicitly alongside Mila's details in MGT1. The guardian holds the legal capacity to act on the minor's behalf, to exercise voting rights, receive distributions, and so on. This ensures the rights attached to those shares are legally exercisable.
That addresses the registered owner. But the law, especially after years of focusing on transparency, cares less about the name on the certificate and more about who's truly pulling the strings.
Which brings us right to Section 89, the Beneficial Interest Declaration.
Right.
What's fascinating here is the Act's rigorous separation between the two identities. Beneficial interest is defined really broadly. It's the right to exercise any or all of the rights attached to a share, or the right to receive dividends or other distributions.
So this is about anti-money laundering and transparency.
It's a cornerstone of the Act's efforts to curb money laundering and undisclosed holdings. It forces transparency on who truly controls the economic and voting power.
And the regulatory burden is placed squarely on both parties, right? It forces a double declaration. What forms do they use?
The registered shareholder, the person whose name is on the register but who does not hold the beneficial interest, they have to declare the beneficial owner's name to the company using Form MGT4.
At the same time.
Simultaneously, the beneficial shareholder, the one who actually enjoys the interest, must declare their interest and the particulars of the registered shareholder to the company in Form MGT5.
And here's the timeline that CA students must commit to memory.
The critical deadline is 30 days. Both the registered owner with MGT4 and the beneficial owner with MGT5 have to make these declarations to the company within 30 days of acquiring that beneficial interest or from the date any change occurs.
And failing to file within that 30-day window.
It puts both parties at risk of severe and potentially continuous statutory penalties. This 30-day filing rule is the foundational timeline for ownership transparency.
Okay, moving on to Section 91. This grants the company an essential, though very strictly controlled, power to close registers. Why would a company even need to do this?
It's purely an administrative necessity. It typically happens right before big events like a dividend declaration or a rights issue. The company needs a static list, a snapshot in time of who is entitled to receive those benefits.
But this power is tightly constrained.
Very tightly. It's to prevent abuse or any kind of unreasonable delay of shareholder rights.
So reinforce those statutory limits for us. How long can a company shut down access?
It's a two-pronged limit. First, the register, whether it's for members, debenture holders, whatever, cannot be closed for a period exceeding, in the aggregate, 45 days in a year.
And the second prong?
The closure cannot exceed 30 days at any one time. You can't, for example, close it for 40 days straight, even if you have days left in your 45-day annual limit.
What about the procedural requirement for announcing this closure?
A minimum of 7 days previous notice must be given before the closure begins. For public companies, that notice requirement involves publication to ensure wide visibility.
So that means newspapers.
Yes. Publishing the notice in 2 newspapers, one in English and one in the vernacular language, both circulating widely in the district where the registered office is. Plus, it has to be posted on the company's website and on the central government's designated website.
Wait, that sounds like a lot of complexity for a simple thing like closing a register for a couple of weeks, especially for smaller businesses.
And that's where a crucial private company exemption comes in. This is vital for compliance professionals to know. Private companies are explicitly exempted from the need to publish this public notice in newspapers and on websites.
So what do they have to do?
They only need to provide that minimum 7 days previous notice individually to their members. It simplifies compliance dramatically for private entities that don't deal with the general public.
And let's not mince words about the cost of failure. What's the penalty here?
It is a significant risk. Noncompliance with Section 91 attracts a steep penalty of $5,000 per day, during which the register remains closed beyond the permissible limits.
$5,000 a day.
Per day, subject to a maximum of 1 lakh rupees for the company and every officer in default. That daily penalty accrues very quickly.
Moving to Section 94, let's discuss the place of keeping and inspection of these registers. Where are they supposed to live?
The general rule is simple. The registers, returns, and indices must be kept at the company's registered office, the RO. This ensures the principal place of business is the hub for all statutory documents.
But the Act provides a logistical exception. How can a company move these critical records elsewhere in India?
The exception requires two strict conditions to be met. First, the alternative location must be in a place where more than 1/10, that's 1/10 of the total number of members, reside.
And the second condition?
This proposed change of location must be approved by a special resolution passed at a general meeting. So if Techno Ltd is registered in Mumbai, but say 15% of its members are in Chennai, it can move the registers there, but only after passing that SR, it prevents arbitrary shifts of records.
Who is entitled to scrutinize these records, and are there any limitations?
Inspection rights are broad, but finite. They extend to members, debenture holders, other security holders, and beneficial owners. But it's vital to remember that a director who is not also a shareholder does not have an inherent right to inspect these records under this specific section.
And what about privacy? I understand Rule 14 places some restrictions on what can be seen.
That's right. While the core registers are open, the intent is to protect sensitive, non-essential personal data. Certain details are prescribed to be restricted. They can't be made available for inspection or for taking copies. The focus is on ownership transparency, not exposing unnecessary private details.
Lastly, what are the preservation rules? How long do these records need to be kept?
The core document, the register of members, including any foreign register, must be preserved permanently. This reflects its foundational importance.
Permanently. Wow.
And the others. All other major registers, like the Register of Debenture Holders, must be preserved for 8 years from the date a person ceases to be a holder.
And the consequence of refusing to allow inspection?
The penalty for refusal is 1,000 rupees per day, up to a maximum of 1 lakh. But more importantly, if the company fails to comply, the central government can intervene directly and order the company to allow immediate inspection. It bypasses any internal resistance.
Okay. If registers are the daily diary of the company, the annual return is the required yearly summary, the ultimate transparency document. Let's transition now to Section 92, the annual reporting mandate.
Section 92 mandates every company to prepare a comprehensive annual return in Form MGT7. And this isn't just a basic form. It's a detailed snapshot covering the company's state of affairs at the end of the financial year.
To give our learners a sense of the scope, what are some of the non-negotiable details MGT7 must capture?
It's an exhaustive list. It covers details of the company's principal business, its shareholding pattern, its indebtedness, all the meetings held, AGMs, EGMs, board meetings, and particulars of all key managerial personnel, or KMPs, and their remuneration. It really consolidates an entire year of corporate life.
Now, a key distinction was introduced to help smaller entities. Tell us about the abridged filing option, Form MGT7A.
MGT7A is the simpler, streamlined version. It's specifically tailored for the one-person company, OPC, and a small company. It also applies to private companies classified as startups.
So the law acknowledges that the full disclosure for a large listed company is just overkill for them.
Exactly.
How do we make sure this MGT7 isn't just a fantasy document? We look at who has to sign it, the authentication requirements.
Generally, for most companies, the annual return must be signed by a director and the company secretary. If there's no whole-time CS, it has to be signed by a company secretary in practice.
But the rule changes for those smaller entities using MGT7A. This is a point of frequent confusion.
Correct. For OPCs and small companies, the law recognizes they might not have a dedicated CS. In this case, it should be signed by the company secretary, but if there is no CS, the document can simply be signed by the director. That distinction, CS first, then director, only if no CS is a critical nuance.
And here's where it gets really interesting for professional compliance. The mandatory CS certification in Form MGT8. Who needs this stamp of approval and why?
MGT8 requires a company secretary in practice to formally certify that the annual return is correct and, most importantly, confirms that the company has complied with all the provisions of the Act. It's essentially an independent compliance audit.
What are the strict thresholds that trigger this mandatory MGT8 filing?
There are 3 categories. 1, every listed company, regardless of size.
All right.
2, any company with a paid-up share capital of 10 crore rupees or more. Or 3, any company with a turnover of 50 crore rupees or more.
So it's an or condition, not an and.
Correct. If a company crosses either the 10 crore capital or the 50 crore turnover threshold, MGT8 becomes mandatory. Hitting just 1 is enough.
Let's nail down the filing timelines under Section 92.4. This is the absolute core of the annual compliance cycle.
There are two distinct scenarios, and both use a 60-day rule.
What's case one?
Case 1. The AGM is successfully held. The annual return must be filed with the ROC within 60 days from the date the AGM was held.
And case two, the pitfall.
Case 2. The AGM is not held. If the AGM wasn't held, the annual return must still be filed within 60 days from the date on which the AGM should have been held.
And critically, in that second case, what must accompany the filing?
It has to be accompanied by a statement specifying the reasons for the default. Why wasn't the AGM convened? This is where companies, like in the Supermart Limited case, go wrong.
Right. They assumed that since the AGM was canceled, the filing obligation was gone.
A fatally flawed assumption. The obligation to account for the year and file MGT7 remains absolute.
And the cost of this failure, the default penalties under Section 92(5).
They're designed to be punitive. For the company, it's a minimum penalty of 10,000 rupees. Then it continues at 100 rupees per day up to a maximum of 2 lakh. For the officer, it's also a minimum of 10,000, continuing at 100 a day up to 50,000. The daily accrual makes timely compliance the only smart option. Now we shift from paperwork to, well, shareholder democracy, the general meetings. This is where strategic decisions get ratified. We start with Section 96, Annual General Meeting, AGM.
Let's focus on the first AGM, which has that much stricter timeline.
The first AGM must be held within 9 months from the date of the closing of the first financial year. So for Infotech Ltd., incorporated April 1st, 2022, closing its first FY on March 31st, 2023, the AGM must happen by December 31st, 2023.
And the critical point for students to remember here is
the registrar has no power to grant any extension for the first AGM. That 9-month window is absolute, non-derogable.
For subsequent AGMs, we face a two-pronged test. What are they?
Both criteria must be met at the same time. 1, the AGM must be held within 6 months from the closure of the financial year. And 2, the gap between the date of one AGM and the date of the next cannot exceed 15 months.
What if a company is facing difficulty with a subsequent AGM? Can they get relief?
Yes. Unlike the first AGM, the registrar can grant an extension for subsequent AGMs for any special reason. But this extension is limited to a maximum of 3 months.
So the maximum potential time is 9 months from the FY closure if they get that extension.
Exactly.
Let's cover the mandatory logistics of holding an AGM under Section 96.
2. Okay, it must be held during business hours, which are 9 a.m. to 6 p.m. It cannot be called on a national holiday. That's January 26th, August 15th, and October 2nd.
And the location?
The location must be either the registered office or some other place within the same city, town, or village where the RO is situated. This prevents shareholders from being forced to travel unreasonable distances.
Wait, if a company is unlisted, that location rule seems really restrictive for modern business. Is there any flexibility?
There is, provided there is near unanimous consent. For an unlisted company, a powerful proviso allows the AGM to be held at any place in India.
Under what conditions?
2 conditions. First, the company must have received consent in advance, either in writing or electronically. And second, this consent must be from all the members of the company. 100% consent.
So, using our example, Pran Limited, an unlisted company in Agartala, wants to hold its AGM in Goa. If they get email consent from 100% of their members, that meeting is perfectly valid.
Perfectly valid. It respects the mutual convenience of the unlisted sector. Now, let's turn to Section 100, Extraordinary General Meeting, EGM. These are meetings called for urgent special business outside the normal annual cycle.
And they're often triggered by the members themselves. Detail the requisition rights. Who can force a board to call an EGM?
Members holding at least 1/10 of the paid-up share capital with voting rights can submit a valid requisition. This power is crucial. It's shareholder oversight in action.
Once that valid requisition is received, the clock starts ticking for the board. What's the board action timeline?
The board has to proceed to call the meeting within 21 days of receiving that requisition. And the meeting itself must be held no later than 45 days from the date the requisition was received.
What happens if the board just ignores the request? That brings in the requisitionist's default power.
If the board fails to act within those 45 days, the original requisitionists get the power to call the meeting themselves.
But they have a deadline too, right?
Yes, the meeting must be held within a final window, no later than 3 months from the date of the original requisition. And any reasonable expenses they incur have to be reimbursed by the company, which can then deduct it from the remuneration of the defaulting directors.
A critical point on location. EGMs are less flexible than AGMs.
That is correct. An EGM called by the board or the requisitionists must be held within India. If the board for Primal Limited decided to hold the EGM in Madrid, that meeting is invalid. The law restricts EGMs to the geographical boundaries of India.
And finally, as statutory protection for the requisitionists, that ensures the board can't just dismiss their request easily.
Right. The board cannot refuse the requisition just because the requisitionist didn't provide an explanatory statement or reasons. The requisition has to set out the matters, but detailed justifications aren't a prerequisite for its initial validity. The board has to call the meeting.
We move now into the detailed mechanics of executing a meeting, the procedural steps that, if you miss them, can invalidate everything. Let's cover notice, business, and quorum.
Section 101 dictates the standard, giving not less than 21 clear days' notice. The word clear is what trips up most students and professionals.
So define 21 clear days for us by detailing the exclusions. This is where precision is everything.
To calculate 21 clear days, you have to exclude 3 key time periods. 1, the day of dispatch of the notice.
Okay.
2, the day of the meeting itself. And 3, if it's sent by post, you must legally factor in the deemed postage duration, which is a blanket 48 hours or 2 days after the letter is posted.
Let's run the numbers with the Madurai Bakes Ltd illustration. The AGM is for September 7th. The notice was posted on August 16th. Let's find the shortfall.
Okay, so posting on August 16th, we exclude August 16th and September 7th. We also exclude 48 hours for postage, so August 17th and 18th are gone.
So the first clear day is August 19th.
Right. From August 19th, September 6th inclusive, there are only 19 clear days, a shortfall of 2 days. The notice is invalid.
And the immediate stress on the company's secretary is immense. What can they do?
They can either cancel and renotice the meeting, which causes delays, or they can try to validate it using the shorter notice consent provision.
Speaking of shorter notice, what is that absolute strict threshold required to validate a meeting with, say, 19 days notice?
The threshold is extremely high. It demands near unanimity. Consent must be given by not less than 95% of the members entitled to vote. If even 6% of the voting members dissent, the shorter notice fails. The meeting is invalid.
Who are the mandatory recipients of this notice?
Section 1013 is explicit. Notice must go to every member, the legal representative of a deceased member, the assignee of an insolvent member, the auditor or auditors, and every director. Even if the business doesn't seem to concern the auditor, they must still get the notice.
And regarding email notice, if the email bounces, is the company still compliant?
Generally, yes. If the company has followed the rules, its obligation is satisfied once it transmits the email. The company isn't usually held responsible for a failure in transmission that's beyond its control. Next, let's analyze Section 102, ordinary versus special business, and the explanatory statement. This defines the nature of the business and the required level of disclosure.
Start by clearly defining ordinary business.
Ordinary business consists of 4 items that are transacted exclusively at an AGM. 1, adopting financial statements. 2, declaring a dividend. 3, appointing directors retiring by rotation. And 4, appointing and fixing the remuneration of auditors.
So if it's not one of those 4, it's special business. And critically, what about an EGM?
Everything else at an AGM is special business. And by statutory definition, all business transacted at an EGM is automatically deemed to be special business.
Which means it requires an explanatory statement. Why is this disclosure so important?
The ES is the cornerstone of shareholder protection. It has to be annexed to the notice, and its purpose is to let members fully understand the meaning, scope, and implications of the business so they can make an informed decision.
And the level of disclosure is extremely high, targeting the interests of insiders.
Absolutely. The ES has to detail the nature of concern or financial interest of every director, KMP, and their relatives in respect of that specific item. If a related party stands to benefit, that must be laid bare.
Let's perform the validity test with the Zorab garments example. A resolution is proposed to increase authorized share capital, but the explanatory statement fails to mention the exact amount of the proposed increase. Is this fatal?
Yes, it is absolutely fatal. The amount of the capital increase is a material fact. Omitting it renders the entire notice invalid under Section 102. The members are denied crucial information. The whole meeting's proceedings would likely be struck down as flawed.
Finally, in this section, we reach Section 103, the quorum requirement. If a meeting doesn't have a valid quorum, it's just an expensive chat.
Correct. No valid quorum, no valid meeting, no valid resolutions. For a public company, the quorum is tiered based on total membership.
What are the 3 tiers of minimum personal attendance required?
1. If the total members is not more than 1,000, the quorum is 5 members personally present. 2. If it's more than 1,000 but up to 5,000, the quorum is 15 members personally present. And 3. If membership is more than 5,000, the quorum is 30 members personally present.
Who counts as personally present? This is a crucial distinction.
This is the key point students mix up. Only members personally present count. A significant nuance is that representatives of body corporates are deemed to be personally present.
And the golden rule regarding proxies.
Proxies never count towards the quorum. If a meeting has 4 shareholders present and 20 proxies, the quorum is 4, not 24. For a company needing 5, that meeting is invalid.
Now, the moment of failure. What happens with a quorum failure? The half-hour rule applies, but the consequence depends heavily on who called the meeting.
Scenario 1. It's a board-called meeting. If the quorum isn't present within half an hour, the meeting is automatically adjourned to the same day next week.
And if the adjourned meeting also fails quorum,
then the members who are present, regardless of their number, become the quorum, as long as there are at least 2.
And scenario 2. A requisitionist called meeting. This is the sharp difference.
If the quorum isn't present within half an hour for a requisitionist called meeting, the meeting automatically stands canceled. The board can't adjourn it, it's nullified, and they have to start the whole process again. Section 5 moves us into the mechanics of how decisions are made, the voting process, and how those decisions are formally recorded with the ROC.
Section 105 deals with proxies, the member's silent agent. What are the key limitations of a proxy?
The role is strictly defined. A proxy can attend and vote, but only when a poll is demanded. A proxy cannot speak at the meeting, nor can they vote by a show of hands.
So they're mute participants unless a poll is taken.
Exactly.
The deposit deadline is probably the single most failed procedural timeline in meeting compliance.
Absolutely. The proxy form, MGT11, must be deposited at least 48 hours before the meeting. The Act is explicit that this 48-hour period overrides any provision in the company's articles that might try to stipulate a longer period.
What happens when a member files multiple proxies? Take member W, who submitted proxy M on April 12th, and proxy N on April 14th for a meeting on April 15th at 3 p.m.
The later in time rule applies, but it's conditional. Proxy N was submitted later, but since the meeting is at 3 p.m. on the 15th, the deadline was 3 p.m. on the 13th.
So proxy N is invalid.
Invalid for missing the 48-hour deadline. Therefore, the earlier received proxy, M, becomes the representative, assuming it was filed correctly.
Members also have inspection rights regarding proxies. When and how can they inspect them?
Section 105(8) defines a specific window. Inspection can start 24 hours before the meeting and ends with its conclusion. However, the member must give the company at least 3 days' notice in writing of their intention to inspect.
Quick note on the exemption for Section 8 companies.
For Section 8 companies, the rule is tighter. A proxy appointed by a member must also be a member of that company. They can't bring in an external non-member agent. Now let's quickly differentiate the standard voting methods.
Show of hands is the default. 1 member equals 1 vote. Proxies are barred. Simple.
Then we have e-voting, which is compulsory for all listed companies and any company with 1,000 or more members.
The poll is crucial when members want votes weighted by shareholding. When must a poll be ordered?
It must be ordered if demanded by members holding at least 1/10 of the total voting power, or members holding shares on which at least 5 lakh rupees has been paid up.
And finally, postal ballot.
This is used for key, serious resolutions where the company seeks approval without holding a physical meeting. Notice is required, and members must reply within 30 days.
This brings us to the formal requirements for resolutions under Sec. 114111. Let's define the 2 levels of majority: ordinary resolution, OR, and special resolution, SR.
An OR requires a simple majority. Votes in favor must exceed votes against, VIF, VA.
Easy enough.
An SR requires a supermajority. The votes cast in favor must be not less than 3 times the number of votes cast against it. So VIF must be greater than or equal to 3 times VA.
Use the XYZ limited case to illustrate. 20 shareholders vote in favor, 5 vote against.
Since 20 is 4 times 5, the condition is met. The SR is passed. If 14 had voted in favor and 5 against, it would fail because 14 is less than 15.
Now matters requiring special notice, like removing a director. Who initiates this?
Members holding at least 1% of the total voting power or shares worth at least 5 lakh rupees paid up can initiate this. They have to give the notice to the company at least 14 days before the GM.
And the company's obligation then?
The company must communicate that resolution to its members at least 7 days before the meeting. If that's impractical, they have to publish it in newspapers.
Our final compliance point here, Section 117, filing resolutions and agreements using Form MGT-14.
The core mandate is clear. Every special resolution must be filed with the ROC in MGT-14 within a swift 30 days of it being passed. That 30-day deadline is one of the most vital in this entire chapter.
But the filing requirement extends beyond just SRs. What else needs an MGT-14 filing?
A few key things. Resolutions relating to the appointment or terms of KMPs, like the managing director. Also, resolutions passed by the board under its enhanced powers in Section 117(3). We're talking major financial decisions like borrowing or investing funds.
Are there exemptions for those board power resolutions?
Yes, and this is crucial detail. The filing requirement does not apply to banking companies, or importantly, to a private company that has maintained a clean record and hasn't defaulted on filing its financial statements or annual return.
We are wrapping up with Section 6, focusing on corporate governance and entity-specific exemptions. Let's start with Section 118 minutes, the definitive official record.
Minutes are the evidence of proceedings. Every company has to prepare, sign, and keep minutes of every single meeting. They are the legal truth of what transpired.
Detail the strict signing and entry protocol.
The minutes must be prepared and entered in the minutes book within 30 days of the meeting's conclusion. The signing protocol is different for different meetings.
How so?
For general meeting minutes, they must be signed by the chairman of the same meeting. For board minutes, it can be the chairman of the same meeting or the chairman of the next succeeding meeting.
There is an often overlooked power vested in the chairman regarding the content, the chairman's discretion.
This power is absolute. The chairman may exclude any matter that they feel is defamatory, irrelevant, or detrimental to the company's interests. So if someone raises an irrelevant point, the chairman can legally exclude it from the official record.
And preservation.
Like the register of members, general meeting minutes must be preserved permanently. They are part of the perpetual record.
Following minutes is Section 119, inspection of minutes. What are the rights of members here?
Members have the statutory right to inspect the minute books of general meetings during business hours for a minimum of 2 hours per day and, critically, without any fees. It's a fundamental right of access. Section 121 report on AGM using MGT-15 requires filing an AGM confirmation report, but its applicability is very narrow.
Indeed, this requirement applies only to listed public companies, not required for any private or unlisted public company.
The purpose is robust governance documentation. The report confirms to the ROC that the AGM was conducted strictly as per the Act and rules.
What are the unique signing requirements for MGT-15?
It has to be filed within 30 days of the AGM's conclusion, and it must be signed by the chairman or they're unable by any 2 directors, one of whom must be the MD, if there is one Andy, the company secretary. A higher bar for authentication.
We wrap up the chapter with the simplest structure. Section 122, applicability to one-person company, OPC. This is a major area of simplification.
This section grants sweeping exemptions. The procedural complexities around general meetings, specifically sections 100 to 111 covering EGMs, notice, quorum, proxies, voting, they do not apply to an OPC. It just strips away the traditional democratic structure entirely.
So how does an OPC formally pass resolutions if they don't hold a meeting?
The method is detailed in section 122(3). For any business, the resolution is simply communicated by the member to the company. It's entered in the minutes book, and then it's signed and dated by the member. That signing date is then legally deemed to be the date of the meeting. It's a hypersimplification to make the OPC structure viable. If we connect this entire Chapter 7 management and administration to the bigger picture, you see that these procedural rules are they're the invisible mechanisms that ensure corporate integrity and protect shareholder investment. We've drilled down on dozens of statutory deadlines, from the 30-day filing requirements for ownership changes and board decisions, to the absolute 48-hour proxy deadline and the crucial 60-day deadlines for the annual return. Mastery of this procedural precision is what separates a proficient chartered accountant from an amateur.
So what does this all mean for you, the student and future professional? Consider the severe implication of a procedural failure, like in that Madurai Bakes case. The smallest mistake, a failure to calculate the 21 clear days notice correctly, can completely invalidate a crucial resolution.
A resolution like altering the memorandum or increasing capital.
Exactly. And that failure means the company has no legal standing for that decision. It exposes it to litigation and noncompliance penalties. Statutory precision isn't just about ticking boxes. It is paramount to maintaining the legal validity of the company's most important actions.
This completes our audio lecture on management and administration, sections 88 to 122.
Keep revising these sections. Focus intently on those MGT form numbers as memory aids, and always study smart and master your future. Thank you for joining us on StudyVix.
Don't forget to like and subscribe.